Welcome to Monday Q&A with Felicia Menta and me, Dr. Deborah Dupree, your IPM facilitator. Felicia, thank you so much again for being with me. I know we've got several hot topics to cover this time, right?
Yeah, school's opening. Very exciting.
Yes, and it's been a very busy time with IPMs. As we've seen the range of schools open from July up until next week and even later. And busy addressing medical issues in the workplace and how people are impacted by what they do. Our first topic today was really about managing unexpected guests at the IPM table. What do we mean by that? Because normally people are invited ahead of time, and yet sometimes we don't know, even though we've asked people to let us know. So point number one is make sure that you, for all of our listeners and the viewers out there, when setting up an IPM, make sure the employee knows they have a right to have family, friend, a union representative, and even some unexpected times, their workers' compensation attorney. Not appropriate, we're going to go into that, but they should let you know in advance because we need to know who to expect. And so I know how to better manage. So Felicia, what are some of your experiences about those unexpected guests? Because I have one recent one that was quite surprising in how it went.
We have had a few recently where the employee did not notify their employer, the school district, that they were going to invite their workers' comp attorney onto the IPM, which they're allowed to do. That's fine, but we like to balance the table, which I'm sure we'll address in a little bit. And so I think about 5 minutes before that IPM was getting ready to start, we found out that the attorney was going to be present. So then we had to really scramble to contact the JPA panel work comp attorney on the defense side to see if they were available so that they could, and they were available last minute and very graciously decided to come on with no notice and no preparation so that we could balance that table. When the district reached out to me, what I explained was that if it's an employment law attorney, then you would want to talk to your employment counsel, your advisory council, or our civil panel attorneys about whether they can attend. If it is a work comp attorney that's coming, then we feel like it should be balanced by the work comp attorney on the defense side is the best person to be there.
Yes, absolutely. Because we always want balance. And I know sometimes employees can feel a little overwhelmed because we might have somebody from risk management, we might have somebody from benefits, we might have somebody from other parts of HR. And so it can feel a little overwhelming. And what I'd like to elaborate on that point, in fact, we just had it happen earlier today. It's real important to sort of separate out the workers' compensation issues, I should say the claim, from the return to work process. Because in workers' comp, attorneys are not necessarily skilled or trained in the employment side of things that ADA and FEHA really address. And so, if anything, if an employee is bringing an attorney, it really should be an employment law attorney, not the workers' comp attorney, because it gets really caught up in the workers' comp claim, and that's not our goal there. In fact, this came up in this case this morning, too. We didn't have the workers' comp attorney there, but it did get caught up that the employee was just now PNS by a qualified medical examiner who did not really assess her physically per se, but her claim is actually 2 years old. And she's actually been back to work. And now it's like, we have limitations, and she doesn't agree with the limitations. And so I had to really help separate out that process of that and what she can do on the workers' comp side, but what we can do on the return to work side, and whether or not she agreed or disagreed with those findings so that we can move forward appropriately. But going back to the unexpected guest is that, again, we want balance. And so if there's somebody on the legal side, whether it's workers' comp or employment law, we want somebody that's also representing the employer. And likewise, it would not be appropriate to have legal representation on the part of the employer without the employee being given the opportunity to have legal representation.
And I think that's a great point, because I was asked to attend an IPM where the school district had their advisory council there, but the employee had not been notified that district council was going to be present, nor were they given an opportunity to balance the table. And the union, unfortunately, wasn't invited to this meeting. And so that caused a real problem, because it seemed like the optics weren't good, right? Like it was the district supervisor and HR and the staff at the district and then their advisory council, but then the union wasn't present and the employee had no opportunity to even invite an attorney to come to help him. So the balancing of the table works both ways too.
Yes, absolutely. Absolutely. There's a few things, about that, not only unexpected guests, like getting notification just a few minutes ahead of time. Fortunately, it all worked out that particular day. And then two is that I like to say unexpected, unpredictable, uncertain developments are troubling, are challenging. And so, if you're going to do an IPM, make sure you give enough notice to the employee. And also, whether or not you use my services, I have a web page that describes the process both narratively and via video. And I'm going to share that website with you because feel free to use it. I'm all about getting information out, just why we have these Q&As. And so the website is https://relationships-at-work/ and then TIP, the interactive process /. And again, direct employees to that. Let them know about what the process involves. I know some districts are excellent about sending out a letter in advance with a description with that link. I also have an attachment when I'm setting up appointments that can be shared with employees or directors or managers or principals who have not been part of the process before. But it's all again about preparing them for the process. And we take that approach not only in IPMs, but also mediation in general. We find that parties are much more equipped to engage in the process, be prepared to deal with the process, much more timely and efficient in managing the process when people are prepared. And that goes along with, letting them know, if they feel more comfortable having someone there. I think the equivalent, Felicia, would be like, sometimes when we have medical appointments, sometimes there's so much being said that I can't take it all in. And so it's wise to have a friend or a family member go with you, just so that they can hear what's being said. And it's much like that for the IPM process too. It's a lot of information. There are several laws involved. Again, we can better deal with unexpected reactions in the IPM, just like uninvited guests or unexpected guests.
And part of the interesting thing about that particular IPM, as many of them, the two doctors on the case did not agree. The primary treating physician and the second opinion qualified medical examiner did not agree about work restrictions. And we had another interesting case just last week where the QME made the employee in the workers' comp claim permanent stationary, said they could not return to their usual and customary work at the district. They did not outline any permanent work restrictions. They said they needed to be rehabilitated, or what we call a qualified injured worker, which we don't really use that terminology anymore. That means that they're entitled to a voucher. But it skipped the whole step of, that didn't help us. It doesn't have anything in it about what they can or can't do. And it's interesting because Athens thought, okay, well then we go right to, we're going to issue a voucher then because we can't even meet because there's nothing to meet on because the doctor has just decided, poof, you can't go back to work in any capacity, right? You're out and you're out the door. And this is also our primary treating physicians and our QMEs. They understand the work comp process. They know next to nothing about IPMs and the ADA and VHA. So they walk us into places where it puts the districts in peril, right? Just because, and I don't think they do it on purpose. I don't think it's malicious. It's actually not understanding. They do understand the concept of permanent and stationary, and the doctor just maybe talked to the employee and they said, well, I can't go back to work. And then they said, okay, my work here is done. You can't go back to work. And that is not even good enough, right?
Not at all, not at all. And so, what you just said, Felicia, actually, runs over into a couple of our other topics today. And so I'm going to go right to the last one because it addresses that specifically. Breaking the tie, when and how to use the fitness for duty and why. And then who pays? Because so I need to go back again when we talk about separating out the workers' comp from the ADA FEHA side of things. Again, treating physicians, PQMEs, when it's a work-related injury, are there to address, yes, functional limitations, but it's really about how you're going to settle the claim.
Right.
Yeah, workers' comp has that provision about looking for modified or alternative work. But what I see a lot of employers get hung up on is that, well, we can't meet. We don't have enough information. It's like, no. Okay, under the ADA, the employee's perception is just as important. Not that we ride solely on it. You have a right to get medical documentation to support the need for accommodation. but the employee's input is critically invaluable. So when there's a discrepancy, conflict in the medical findings, that's exactly when you should be scheduling an IPM and then determining the course of action to now what next, because you have some additional options like through a fitness for duty when it's a return to work issues and doing so in a timely fashion, as opposed to throwing it back into the workers' compensation system. And going back to the case we were talking about where all of a sudden the employees of the workers' comp attorney was showing up and the defense counsel showed up, thankfully. And because the employee's attorney, it's getting a little contentious. It's like, well, wait a minute, calm down. We're not here about that stuff. We're here about return to work. Do we need more information? Yes. But here are the options, because that's going to take a long time. Going back to a QME is going to take a long time. And then what do? The employees stay out of work. Do you provide them with temporary modified work, or what? Because you can't go back to work if we have information that suggests risk or harm. And that's what we had. And so in that particular case, though, unfortunately, the employee opted not to go through the fitness for duty and wanted only to go back to the QME. Okay, well, fortunately, the employer was able to provide alternative duty for the time being. And so it worked out. But the thing is that there's still some concerns. And so what was done then is that we felt that enough of the risk was mitigated by putting her into this alternative job. But if the QME came back, because now the QME, the other thing was the QME had not even read a job description. The employer had not provided an existing job analysis. So here the QME is making decisions only on what the employees told them, not on the actual job functions. And so even in the employee's description versus the reality of the job, there were discrepancies. And it's like I cannot go on what the QME is saying, knowing that the QME has not read the job description or the job analysis. Now, if the QME comes back and has limitations that precludes the person from doing the alternative job, then we'll have to meet again. We'll have to reevaluate, But again, a more timely thing, because you've got a lot of repercussions in not doing a timely engagement in the interactive process. And we'll talk shortly about that. But you've got to separate those issues out and not just wait for whatever's happening in workers' compensation.
Right. And I think the timing, your point is so good on the timing. QMEs have 60 days from the time that we request supplemental information to get a supplemental QME report out. So, and a lot of them are late even with that. So I would say 60 to 90 days. And that's from the day that we request the information. Here's the job description in your permanent stationary report. You didn't address return to work. You just said she can't return to work. We need to know exactly what her work restrictions and limitations are. Could you please advise? That is going to be a 3-month process. That's what I tried to tell the district. Try to think about that. That's the timeline of how long you're not going to know. Get clarity. Primary treating physicians, it can be faster because we can't have ex parte communication with a QME. We have to have agreement amongst all the parties before we even send them the request for the information. Primary treaters, we can talk to them on the phone. We can call them up and we can send a nurse to their office and ask them to please clarify right there to the nurse. So we can do things a little faster. That's about a 2 to 4 week resolution of the information, but not with the QME because that's a formalized process. Whereas a fit for duty still takes time, as you and I know. You're scheduling the evaluation, and then from the time of the eval, I would say most fit for duties come in 30 days with the report and the bill. And then the conversation we have a lot of times with the district is that is a district sponsored and paid for and requested evaluation that can't go in the work comp file, that cannot go to the claims examiner. That is something that is private and needs to be kept out of that file. That is something that the employer is doing specifically to resolve a return to work issue. And a lot of districts don't understand that. They think that workers comp can pay for that on the file.
No, absolutely. And again, it's real important. I mean, we're all coming together and sometimes based on medical information from the workers' compensation claim. But that's a whole entity of law and administrative rules that have nothing to do about the return to work piece of it. And that's where it is interactive. And on that note, again, the IPM I just facilitated this morning, few missteps, if I would say, on several parts, is that the employee actually had a second injury in 2020, same body part. And she has been back to work the last year, but she was not yet at maximum medical improvement.
Right.
And there were some functional limitations, but the employer felt that they could accommodate, and she's actually been back doing her regular job. And
So was she on temporary accommodated duty for a year?
that's my understanding.
Wow.
Yeah.
Okay.
And
That's a long time.
So yeah, a couple things is that, please employers abide by your guidelines for temporary accommodation. Because if you continue a temporary accommodation beyond the recommended 180 days, most school districts 120, you have just created a way of life for that person in that position for your district. And you really will run into trouble if you try to take away the accommodation. And so that's sort of what happened today, is that, she's already been working the entire year. She's already been back to work this year, but she just became MMI by �PQME in the early July. The employer just got the report with last week. We set this up very fast. And so she's taken off guard. The employer's been taken off guard. And so it was a lot of just quelling the angst of what was going on. And there were some limitations that had no application to her job duties. And so I had to clear that up. It's like, I know, we know that. It's this piece of it that we need to clarify. And so she readily acknowledged she picks up her grandchildren that weigh more than her 30-pound lifting limitation. And she didn't agree with the findings. And so we explained her options. She has a right to go back to her attorney in the PQME process. That's on workers' comp, but that doesn't deal with the return to work now. And so in that regard, there was an offer to do a fitness for duty to get this matter cleared up as soon as possible. Where the workers' comp claim goes is not our concern. It's getting her back to work in a timely fashion. So employers, as soon as you have knowledge, not only of an employee with a medical condition, but their maximum medical improvement status, you gotta take action. Yeah. But the fitness for duty is a great place and to get things resolved, and a true assessment of someone's physical capabilities or cognitive psychological capabilities too, because we do them on the latter half too. Yep.
It is difficult because if you do have a work comp attorney defense and on the applicant side, their expertise is not in ADA and BHA. So when you start talking about fit for duties, that really becomes like they don't even understand that process, because that's not a process that we do in workers' comp. So you are right that those attorneys really shouldn't be present at an IPM, because they sometimes can make things more complicated than they already are.
Yeah.
It's outside their scope. That's
yes.
what I think.
Yeah. Well, and the analogy I use for the employee today is, like I said, you had to go through a pre-employment physical exam, right? A fitness for duty is really sort of like that too. You got your job description and so forth. Which on another note is that we just had a new employee hired that she passed the pre-employment physical. We're questioning whether or not they had the right job description and job analysis that was already existed, because she then brought in functional limitations that could not be accommodated. And yet she was already at work. And so it's like, oh my gosh, what do we do now? And so she is going back to her doctor, because it turns out the note was 2 years old anyway. And,
it's not current.
Yeah, I said, we have to have current information, and if you feel you can lift more, then you have to be able to provide that, but you're going off work in the meantime. Because we can't risk their
usually
safety.
sometimes you send the person home while you're seeking clarity if there is a direct threat issue going on. But to your other point, I do agree. I was at an IPM a few weeks ago where the employee had been being temporarily accommodated for 2 years in a temporary accommodated position, was not permanent stationary, became permanent stationary, and had many of the same work restrictions that they had been having the whole time for the 2 years. But again, didn't adhere to their return to work policy, whether they had a 60+60 or 90+90. 2 years is not anybody's normal return to work board approved policy. And you're right. Then the response was, we're not going to be able to accommodate. You're going to need to go home and go off on leave and go on 39-month. And then the union said, oh, we're going to sue you. We're going to sue you because if you can do it for 2 years, that is his job now. You've been accommodating in his department, in his position, providing help for him. We don't see any way that you can argue you're unable to do it now. And that is the exact reason why you want to have a return to work program and try to adhere to it, in a very fair manner with all injured employees.
Right. Yeah. And in the EEOC at the federal level for the ADA has long talked about, not making temporary accommodations more than a max of 180 days. And as we know, a lot of school districts have a shorter time frame, oftentimes bargain, sometimes not at 120. But yeah, there's been cases decided on this years back that have said, if you continue something on, you've just created a way of doing business, and you really create an undefensible argument against continuing that accommodation. And it really upsets the apple cart in lots of different ways, because employees are going, what? Why does that person get ongoing accommodation? And so it's really important to be consistent with your practices and have that interactive process, because you can really explain the process as well as work through, the employee's fears, and, managers, principals, and supervisors understand the implications. I just had a conversation with another major school district here in San Diego County, and the two key people are relatively new, maybe in their jobs about a year. And they both have just said, wow, it seems like a lot of accommodations were allowed to go on. And I said, well, I know what you're talking about. I've seen that there too. And I said, unfortunately, unless employers or district offices, risk management, human resources, provide some education, a lot of times, the employee tries to work things out with their local principal or their
at the
local
site,
manager.
and the district doesn't even know, the district office doesn't even know what's actually being done.
Right. And so again, a lot of times I see those accommodations as inappropriate. They're not performing all the essential functions. They're not, adhering to the schedule. And so again, now you're creating unfair work practices. So a whole nother layer of employment law that becomes very difficult to navigate through.
And I will say that it happens sometimes where you're right, the site or the district office loses track of somebody, and they're being accommodated a lot longer than the policy actually states. But I also think if you pick that up and then you notice it, and even though you've gone beyond the time, then you're right, you're meeting then, and you're also trying to work with the claims team to get a permanent stationary report. We can do things to try to seek opinions that say that the condition is now permanent and stationary. It just takes a long time to work through the comp process. I would say most people aren't with surgery or that have major injuries, they're not permanent stationary for 6 to 9 months. And some people not until a year or two if they've had multiple body parts and multiple surgeries. It takes a long time to get through a back surgery. That would be an example, or a total knee. And especially if you have a follow-up hardware removal or further surgery. So you really have to keep track of those people, where they're at, what kind of leave they're on, how long they're on temporary accommodated duty.
Absolutely. It is a tracking process, and it is a different element of internal management that needs to happen on behalf of your employees. Absolutely. I want to segue over to, we've touched on it, the importance of taking action, but our second bullet point was red alert, urgent action needed that can cost, and the cost of untimely action when MMI limitations exist. And so I think we know of a few situations of late where action wasn't taken when the MMI notice was done. And this comes from the workers' comp side of things. And it does have implications on the ADA and PHA, but it would take additional steps to even file that claim. But in workers' comp, say a little bit about that, Felicia.
So every single report, and this is something that the claims team and the risk management department and our HR at the school district have to work together on. Every single permanent stationary report, not the report itself, but just the blurb in it about the return to work has to go over to the district. And that really should be red alert, all in caps. We have deadlines, right? So on workers' comp, we have different deadlines than we do over in ADA FEHA. In workers' comp, we have 60 days from the date of the permanent and stationary report to meet with the injured employee, either on your own or with a mediator such as yourself, and then make a decision whether you can accommodate or not, or get clarity, seek clarity if you need it, and make a letter offer of return to permanent modified work or alternative work, or the claims team has to issue a supplemental job displacement voucher of about $6,000. And this does not put you through medical school or college by any means. This pays for a laptop and supplies and maybe a certificate program, that you need, something short. But we have to pay it even if you were going to accommodate and offer them a letter offer if the time goes by. So we've had several districts balk saying, I don't want to pay the $6,000 voucher. for the employee to use, because yes, we didn't meet and it fell through the cracks, but we're going to meet now and we're going to return them to work. But those are not the rules. The rules, and we just paid 4 or 5 voucher amounts that we really probably didn't need to, but we had to because the district did not do the meeting, did not get through the process, and did not make a letter offer. And that requirement is very stringent. You can make discussions about whether or not you don't have enough clarity in that report, but you really need to meet and start the process. And then over on I'll let you address it, on the ADA 𝐫𝐻A side, there is no 60 days. You're supposed to meet in a reasonable period of time, right? And so I feel like the note from the claims team should be on fire with little flames, right? It's really important.
Well, graphics do get our attention. So
yes, little flames on the
hot.
side. This is hot.
I will go there, and I'll just share with you that with this particular district, unfortunately, it was 5 total. We actually we're completing some of the IPMs, 2 of them anyway, last week. And it turns out it's a husband and wife. They have different jobs entirely. And unfortunately, they both have had work-related injuries that they've been recovering from. Both have been back to work, all of last year. But because the IPM was never done, they just became MMI recently. So, as a family, how great it is to get $12,000, bonus time,
Yeah.
And so when you think, just like employers may balk at, well, we can do, the IPM ourselves. Well, yeah, you probably can, although it can get really complex, like the one I just had this morning. And the HR rep was just so thankful I was there. And that way I can become sort of the heavy when I try to bring boundaries to things, and you can still preserve your employee-employer relationship. But the same, it's the same as the fitness for duty, or FFD. They're usually less than $1,000. The IPM is $600. And so think about $600 or $1,000 compared to $6,000. Okay.
Right.
And then on the ADA, and a little plug for your program coming up in October, and I'll have you talk about that. We'll go into much more depth about this, but there was just a major case, a verdict decision about an employer's failure to engage in the interactive process and then trying to terminate an employee. And I know that was one of our other topics we were just going to touch base on briefly, but why don't you say a little bit more about your upcoming program, as well as, who's going to be there and what's going to be talked about, and the implications of the Keenan case.
Okay, sure. Yes, so we're having a webinar on this very topic that Athens is putting on August 23rd, 22nd at 1 o'clock for our members on this interaction between the ADA 𝐫𝐻A and work comp claims, specifically dealing with the Keenan civil jury trial that just happened. There was a jury trial that concluded on May 24th, 2022 in Santa Cruz. And the employee alleged that he was wrongfully terminated from his employment with Santa Cruz City Schools. And a jury trial proceeded against the district's work comp administrator, Keenan and Associates. The employee alleged that Keenan repeatedly misrepresented his work restrictions to the district. And I'm just reading from the jury trial notes, and that Keenan altered certain medical reports before providing them to the district. And so on May 23rd, 2022, the jury returned a liability civil verdict finding that Keenan had conspired with the district to violate 𝐫𝐻A, and that the jury found that Keenan aided, abetted, incited, coerced, or compelled the district to violate 𝐫𝐻A or attempted to do so. And the jury awarded $6,908,000 to the employee in compensatory damages, or the applicant. I don't know if he was an employee at the time of this trial. I don't think he was. But the jury found that Keenan acted with malice, oppression, or fraud. And so a punitive damages phase of the trial commenced the next day, and the jury returned punitive damages verdict in the amount of $27,600,000, bringing the total damages awarded against Keenan to $34,508,000. And so because this is such a big case involving a school district and their work comp administrator, we're going to be focusing on this case with yourself and our civil attorneys in our fall workers' comp training meeting, which we invite all districts to participate in, to kind of talk about the perils and what happened in this case, and how careful you need to be in these cases.
Absolutely. And so we have 2 excellent employment law attorneys. Would you like to share who they are so people can be...
So Randy Winnett and Jennifer Creighton from Winnett, Patrick and Wheeler, who are on the JPA Civil panel and try lots of cases, are very, very experienced in this area, and they're going to be kind of breaking down the jury trial and what happened, sort of like the facts of the case, because we always use these things as educational, right? So that we know sort of what to avoid.
And that date in October is when again?
We're still solidifying the date
Okay.
because of Randy's trial schedule. He has a bunch of trials. And so it is going to be either at the end of September or the beginning of October, because we want to do it, you know, pretty soon, because this is a big jury verdict, and this is a civil verdict, not a workers' comp, but it's surrounding, and it sort of further solidifies what we always talk about at the litigation in these cases: the failure to accommodate, the failure to meet, disability discrimination and wrongful termination don't live in the workers' comp world. So the results aren't there. So this is the first big case where a finding has been held against the work comp administrator, you know, and the schools were a co-defendant in this case. Santa Cruz was.
Right. Yeah. So a couple of things there is that, you know, as you said, this is the first time we found a third-party administrator at fault, and yet the district was relying on them as their experts. But again, Keenan is not an employment entity; it's a workers' comp entity, and that's why, you know, having Randy and Jennifer is so very important to break down and digest all of this. Now, there have been other big cases against employers directly, and I've shared some of those on previous, a Monday Q&A. It's so important to be proactive and looking ahead and being aware. And that's why I always encourage people to contact the Job Accommodation Network as a resource, for one, because they are generally very up to date on the latest and greatest what's happening in jury decisions, as well as changes in EEO guidance. Again, this is on the employment side of things. And the ADA, which turned 32 years old back on July 26th, actually, and I always tell people this law has been around for a long time, so it's really nothing new, but a lot of people still don't know about it. And unless you have an employee with a medical condition, or you are the employee with the medical condition, or you're an employer who now has an employee with a medical condition. And so because they don't happen that often for a lot of districts, it really is important. I've been known to say it takes a village to get someone through this process. In not all cases, many are very easy, and the EEOC has said if it's really a very apparent, readily achievable accommodation, you may not need to do an IPM, but most you do. Because there are usually ongoing issues, but I wouldn't risk it by saying, oh, I don't need to do one. It's like, we just found that out in the Keenan verdict. And so it's long been held that under the ADA, each damage found by a jury, like in the Keenan case, is up to $300,000 per identified damage. And so that can rack up, and even more when you talk about lost wages that sound like it may have occurred, legal fees, things like this. All of that gets wrapped up. So that's a huge financial burden when most don't have that kind of money laying around.
Well, and it does make the fit for duty cost of under $1,000 and the IPM cost well under $1,000 look a lot more reasonable, right? When you see the peril. And I guess because I know about these perils because I work closely with our liability department and with our civil counsel on some of these matters, I know how much more the damages are over there than the value of workers' comp claims.
Yeah. And so there's always, I know we've said this before in our Q&A sessions, that, I've been doing this since the ADA and even before, because I was a voc rehab counselor in workers' comp during the 80s. And so then when the ADA came along, I was actually in state leadership at the time to make sense. What does this mean for workers' comp? It can be complex, and it's not something, again, that you want to undertake on your own. And both you and I are readily available for quick consults. What do you think about this? And it doesn't mean you're committed to using my services, but, reach out, talk to other people, talk to, your employment law attorney, just to say, okay, we got the situation. What do you think? And many times you and I will collaborate on together. Well, how do you see it? How do I see it? And how does the claims team see it? How does the employment law see it? Because these are important decisions, and we don't want to go it alone, for sure.
And we have, I have to say, in workers' comp, and the examiners have this too, the rules are much more black and white than they are on the employment side. We have real parameters of, yes, you can do this, no, you can't do this, yes, you can do this, this has a fine to it. It's a very jurisdictional law that has a lot of black and white pieces to it. Employment law is not like that, right? We get these examples of cases of what's happened and when the employer wins and when they loses. And really the ADA, BHA, and all of those return to work issues live there in employment law. So never ever should a district ask their claims examiner advice about what to do about return to work, because again, not their scope, right? They stay in the workers' comp. Per workers' comp, the rules are this, right? But per employment law, the rules are completely different. So
Yes.
you have to seek a different kind of counsel, right?
Yes, and what I'll share with our viewers and listeners is that it was actually more than 2 years ago where I had the head of the ADA employment law practices within 𝐸𝐵𝐠 that was on my podcast.
Oh,
and
yeah, he was wonderful.
Yeah, and we talked exactly about, the distinctions between workers' comp and the ADA. And as he mentioned there, and I'd never thought about this, is that even FMLA has more precision about what to do, how to do, when to do, than the ADA. And that's the complexing part of the ADA, and is that it really left a lot to interpretation as well. And I'll go back to the case-by-case basis. The process is the same, but you have to evaluate what comes out of it on a case-by-case basis. And that's
what I think the districts really struggle with, is when to accommodate and when not to accommodate. Because anytime you're not going to accommodate, there could be peril, there could be litigation. But anytime you are accommodating, there could be risk, right, to our students, which we're liable for, and to possibly our other staff, and to our employee themselves, right? Because OSHA says we have to provide everyone a safe place to work. And that's where I think it takes everybody to try to weigh in to make sure that we're making the best, that the decisions that the districts are making are the best decisions.
Yes, absolutely. And I'll just share on that note too, Felicia, before we begin to wrap up then, is that on my IPM I just did this morning, the HR rep said, I didn't expect this outcome, but it makes sense, So what the deal was is that, she could largely do her bus driver job duties, but her limitations, so the bus driving was okay, but the limitations really applied to doing the morning pre-trip inspection. When she had to open and close the hood of the bus. And then what is the bus driver's responsibility when there's an emergency or an accident? To remove students from the bus. And so it's like, it's only once, hopefully it never happened, but it's like a firefighter or police officer, it can be a rare occurrence, but when it happens, you have to do it. That's your job. And
similar to performing CPR, if students are incapacitated on a bus, you better be able to do CPR because you might be called on to do it. So maybe you can't do it normally on an everyday basis, but you have to be able to do it when you can. So that becomes difficult too, right?
Yeah, and without risk of injury or harm to yourself or to others. And so that's a very definite provision within the ADA. And that's why we have to look at this so very carefully. And that's why Fitness for Duty, again, is that you say you can do that, this doctor says you can't. And so here's what we can do is actually physically assess your capacity. And again, it's a quick way, a fairly low cost way to get clarity on the situation. So I can't advocate that enough. That's usually the tiebreaker, like we said before. Yep. So I just want to, I'm passionate about what I do, and I know you are too, Felicia. And I like helping people, stay at work, and that's what the ADA and FEHA are really about, is keeping people at work. Right. With or without accommodation. So that's what we have to evaluate for. And I'm here to assist. I know you're here to assist. And I encourage people, one of our topics was the art and ease of online scheduling. There are a lot of moving parts, moving people at the district level. And so I said, well, I'm going to bring my online scheduler to this process, because then that way you can have access to my schedule to quickly find what works on my end and what works for all of you, because there's usually a lot of coordination on your end as far as everybody who needs to be there. But doing the IPMs on Zoom, and this is true for mediation. In fact, I'm going to be a keynote on Thursday about hybrid mediations, Zoom mediations, in-person mediations. And we just did a survey where among attorneys, these are all kinds of attorneys and mediators, that 70% of the people said they're going to continue online because of the
with doing the online meetings.
Yeah,
Mhm.
because they're easier to schedule. We don't have travel costs involved and travel time. And it's actually, again, across the nation, probably globally, it's just much more efficient and much more cost effective for everybody concerned, whether it's time and actual money. And so I encourage people to, I'm putting together a small program about how to do that with some visuals so people understand, but it's pretty darn easy. So I put
We've done some Zoom where the employee doesn't have maybe the setup at home. So they come into the district and then they all Zoom in together from there. And that's worked out too. you
Right.
know.
Right. And that's exactly the IPM I had today. The director of the department, the HR rep, the employee, and her CSEA rep were all in their conference room with social distancing. I know it's changing now, but I was virtual, but it went wonderfully. Yeah. And no travel time. So yeah. Well, Felicia, any parting words? I know that you're going to be letting us know about the date of your fall JPA conference, and we'll be talking in depth about the Keenan decision. I think you also told me before we got started that Dr. Head is coming in to say a few words about.
Yes. I've asked Dr. Head if she is available to come in and talk about where the county is. You know, we just went from the red to the highest tier down to a lesser tier, which that's a good thing. But we did still see San Diego Unify requiring masks. And I noticed San Diego State opening for the fall is making masks mandatory. We don't have too many of our members. It's mostly highly recommended, but not mandatory. Sweetwater, I think unvaccinated staff and adults must wear a mask in the presence of children. Is that your understanding?
That's my understanding So things continue to evolve.
Yeah, so we'll see where we go because we're opening last week, this week, next week. And because I can see into the Athens COVID-19 portal, I can see that the cases are ticking up. So we'll see where we go. Yep.
It's an ever-changing world.
Yes.
Yep. Well, thank you again, Felicia, for being here with me today. Thank you to our viewers and listeners. Again, 4 key topics: manage the unexpected guests at the IPM table, red alert, take action when you've got an MMI status. And then also, breaking the tie, when and how to use a fitness for duty. And then also the ease of online interactive meetings and using my online scheduler. Here to help you, here to serve you, and here to support you. Thank you again, Dr. Deborah Dupree. Felicia?
It was my pleasure, as always. Really enjoyed it.
Great. Thank you. So again, a reminder, we will have a recording link prepared and sent out to you usually within a week or so. Include a couple other resources, and then watch for notices on Felicia's upcoming JPA Fall Conference. It's sure to be a powerhouse and a lot of good, insightful employment law insights into what does this mean and what should we take note of. Okay, so thank you again. We'll see you in another month. Bye-bye.
Bye, everyone.